I don't do too many district court cases, but this New South Wales District Court case is one of the first to really apply the relevant provision of the Civil Liability Act. Mr. Gray was a picker-packer at a grocery distribution warehouse. A picker-packer drives around the warehouse with a forklift and collects groceries for an individual supermarket. The job involves lifting and carrying heavy bulk grocery items, so proper lifting technique is vital. The employer trained employees in proper lifting technique, and the written procedures for the workplace included the use of proper lifting techniques. On the night in question, Mr. Gray was lifting a shrink-wrapped allotment of 24 bottles of water. It was almost the last water on the pallet, so it was right up the back. He had to use what was called a lunge lifting technique to reach in and get it. He injured his back lifting the water. One allegation in court was that the employer could have removed this risk by using a process called pallet rotation, where as soon as a pallet was half empty, it would be pulled out and rotated so that the picker-packer never had to go up the back. That would obviously have meant more staff and more equipment, but it would have prevented the need for people to reach into the back of the pallet. The judge found that lunge lifting was a reasonable method of controlling the risk of reaching into the back of the pallet, so the judge found that there were two reasonable ways to deal with the risk of lifting those goods in the back: pallet rotation or the lunge lifting technique. Section 5 capital C subsection B of the New South Wales Civil Liability Act says the fact that a risk of harm could have been avoided by doing something in a different way does not of itself give rise to or affect liability for the way in which the thing was done. The judge applied this provision and said there is no evidence that pallet turning, being a different way of doing something, would have avoided the risk of harm. In other words, lifting would still have been necessary, and safe lifting technique should have been enough to manage the risks without the need for pallet turning. The employer had met their duty of care, and the employer was not liable.